We're very pleased to have this very eminent group of panelists here. Leo McGrady, who has written The Protester's Guide to the Law of Protest and has given legal advice to civil disobedience activists over the years. We have Professor David Millward, who is a professor of Indigenous law here at the University of Victoria, who will be talking about the role of Indigenous law in this context. Karen Campbell will be talking about very briefly about the Declaration of the Rights of Indigenous People and the relevance of that in relation to these cases. We're very excited to have Lauren Regan from Oregon, who's with the Civil Liberties Defense Center and has successfully used the defense of necessity in climate change protest cases. Keegan Pepper-Smith from EcoJustice is going to talk about the current state of the necessity defense in Canada. And finally, we're very privileged and honored to have Professor Kent Roach, who will be responding to the comments of the panel. Kent is one of the preeminent lawyers in Canada, named by Canadian Lawyer Magazine as one of the 25 most influential change-making lawyers in Canada, and of course, the author or editor of Constitutional Remedies in Canada, which has been quoted numerous times in the Supreme Court of Canada. So with that, I think that we'll just start. We've got a lot to cover here. And we're going to start with Leo McGrady, who's going to be talking about his long-term dedication to assisting civil disobedience actions. He's run a number of legal workshops in civil disobedience. He's written The Protester's Guide, and he has a particular interest in the intersection of Indigenous law and colonial law regarding these cases. So, Leo, take it away.
Thanks, Calvin. And thank you for the invitation to participate in this extraordinary session. Some of you may, I hope, have had an opportunity to look at the material that Calvin distributed. It's included in that bundle of material is an excerpt from one of my guides. This one is one that was prepared in 2014. Early on in that year, I was asked to begin a series of workshops for First Nations, and I started in Terrace and then went to Kitimat, Prince Rupert, and then worked my way down through a number of the different coastal communities doing this workshop. And what was quite delightful about it is that a number of the participants on each occasion downloaded copies and printed them out and took them and did their own workshops to the much larger group in their Indigenous community, or in the Terrace group to the Indigenous community, but also the environmental community as well. And the Terrace workshop was an absolutely extraordinary experience. It was on that amazing longhouse, Timshin Longhouse, that opened there a number of years ago, which is truly one of the most beautiful buildings I've ever seen. And I felt very honored to be able to present this material in that setting. What I'd like to do is just make mention of the other versions of the workshop. They're listed on the cover. There's the Wallbrand from 2015. What's significant about that is that the entire workshop was filmed and is available on YouTube. And then there's the Canadian Association of Labour Lawyers workshop that was delivered in Montreal in June of 2017, Site C Summit in Victoria 2018. All of those are on my website and readily available to e-copy or download or distribute or cannibalize and use for your own publication, whichever suits your purpose. What I thought I would do, it's the book or guide is quite lengthy. I think different versions have gotten to about 100 pages. And what I'd like to do is just to acquaint you with some of the key parts of it in this 15 minutes that I have. The excerpt that you've got is down if you have the table of contents open down to the heading demonstrations. But I just wanted to mention from that point on, for the next 10 or 15 pages, there's some very practical advice about what to bring to demonstrations, what to leave at home. My favorite silly moment in advising people who were about the demonstration is getting into a discussion about whether or not they're going to be permitted to take drugs, or whether they should be found with drugs in their possession when they're at these demonstrations. And that was all, of course, pre-legalization. There's advice on what to say, when should you disperse, how to deal with riot police, social media censorship controls. A key part that was added a few years ago was the next one, legal observers in patrols. And it sets out the protocol for a very, very key part of a successful demonstration, and that is to have observers that are distinct from the demonstrators, stand out with their T-shirts or whatever, and their object is to be there and do, as the term suggests, observe the demonstration and position themselves to give evidence later if that becomes necessary. But that's something that we learned from the Chilean student demonstrations of the previous year. And those folks developed it to an extraordinary degree. And I've had the benefit of getting access to a lot of their recommendations, and I've included those as well. And then if you drop down to just above detention, hijacking your protest, that's become a very serious problem recently. And so we added a long section on that. And the Black Bloc is the group here in Canada that typically hijacks the demonstration. And once they become involved, there's no limit to the tactics they will use, torching police cars, breaking shop windows, things of that sort. And then even more recently, the Yellow Vest demonstrations in France that has, while it started out with admirable objectives and tactics, it's since been taken over by right-wing anti-Semites. So those are things you've got to be careful about when you're developing your plan for your demonstration. And then if you go to the next page, what I've done is included the key charges that are most frequently laid in demonstrations, how to avoid running afoul of the law there. I talk about searches, and I talk about other issues, complaints against the police, false imprisonment, interception of private communications, malicious prosecution, and then injunctions in contempt of court. And just on that point, one of my colleagues from my firm, Murphy Freeze, she and I did a presentation that was recorded for the Law Society Library, for the BC Courthouse Library, and it's available to anyone. And so if you're dealing with either injunctions or contempt of court for the first time, that's readily accessible for everyone, not just lawyers. And you can have a look at their website and immediately access that material. So a couple of quotes that I'm very fond of. The first is from The Inconvenient Indian by Thomas King. Many of you would know him as a Cherokee activist, a teacher, and a writer. But the quote, for those of you who don't have it in front of you, the idea that justice is blind and that everyone is equal before the law reminds me of a traditional story that I've heard over the years in which Coyote tries to convince a band of ducks that he has their best interest at heart. And then my probably all-time favorite quote is this one from Nathalie Desrosiers, who was at the time the General Counsel for the Canadian Civil Liberties Association. The rich people have their lobbyists and the poor people have their feet, if that's not sufficient incentive. And And then I go to page 4, and I just want to make mention of a conference that I spoke at in December of 2012 at the SFU Harbor Center, and it was sponsored by the Lawyers' Rights Watch Canada, Amnesty International, Council of Canadians, and the journalism program at SFU. And I'll say more about that in a moment, but it was an absolutely extraordinary panel. And as you'll see from the comment that I'll make shortly, one of the real strengths and pleasures of doing these workshops that I think you'll find if you do them yourself is what you learn, which is quite an immense amount from the people that you're delivering the workshop to. Now, I spend a good deal of time from that point on to deal with what I've called the First Nations edition, and that goes on for several pages. And what I thought I would do, I know Professor Millward's works, and I'm very anxious to hear what he has to say to us today. And so I've decided, and I've let David know this, that I'm just going to skip over those portions because his material is mine pales in comparison to the work that he's done and what he will be telling us today. If you, in addition to reading David's material, which was sent out, distributed to us today, if you wanted to get a perspective on it from the former Chief Justice Lance Finch of our Court of Appeal, there's a reference on page 5 to an article of his that was delivered at a recent CLE that really does say it all. And then going to page 6, I talk about a lot of people have asked about the origin of the title that I had given one of the workshops, which was Cedar as Sister. And I set out the explanation of that, and it's from an argument that was made on behalf of the Indigenous community before the Supreme Court of Canada. And then going to page 7, if you'll go to the second last paragraph, you'll see the conversation that I had at the Simon Fraser, the Days of Dissent conference at Simon Fraser University. And in a discussion with Chief Philip Lane, up until that point in time, all of my books and versions had been entitled Civil Disobedience. And the point that he very generously and kindly made to me was that was completely erroneous, and that the Indigenous people, when they're not engaging in civil disobedience when they're protesting these issues. It's their land and fishing rights that are being jeopardized by the illegal conduct of governments and the corporations. The only conduct that is disobedient is that of governments and corporations. Then I go on to talk about some of the more dramatic protests over the years, the Ipperwash protest, the Oka protest. The next issue, I'll deal with the Gustafson Lake protest as well. And then if I can take you to page 12, I start there dealing with other examples of civil disobedience, and I won't mention them all. One of the ones that stands out is the ACT UP gay and lesbian protests that began to appear in the media and in print in the 1980s. And there's a good deal of material available about those protests, but they were certainly some of the most effective and some of the most remarkable protests in the history of civil disobedience. And then I talk about the Clayoquot Summer of '93. This is on page 13, 850 arrests. Some people have talked about that as really demonstrating that in order to make a powerful statement about your protest, there has to be some arrests. I'm not sure what my perspective is on that, but that's an argument that you do hear from time to time about folks that are advocating civil disobedience. If I can take you to the third paragraph on page 13. What I've found over the years is that if you can include humor in your protests, that tends to gather a great deal more attention. I've never been entirely sure why. And it also adds a measure of credibility to your protest. And so what I've talked about there is one of the classic examples from guerrilla media in 1997. They published mock editions of the Vancouver Sun and the Vancouver Province and inserted them into the newspaper boxes. And they even published their own dictionary, and tongue in cheek to Conrad Black, who had not yet begun his prison term and was still a media magnate. Whenever one of Black's editors came up with a suspect word such as corporate agenda or child labor, the word would immediately be transformed into a corrected phrase. For example, corporate agenda would become common sense. Child labor would become youth reliance program. Sweatshop would become profit center. There's other models of effective civil disobedience. The critical mass bike ride, I deal with that in some detail. I think it's a wonderful example of effective civil disobedience. One of the other favorites is the effective use of props in the course of civil disobedience in Quebec City during the Free Trade of the Americas demonstrations. A giant fence was set up, and immediately behind the fence were several thousand riot police with full militarized equipment on. But then on the other side of the fence, the protesters wore pots and colanders on their heads. They built a full-size catapult and used it to lob teddy bears over the fence and onto the riot police. The protesters were accompanied by a kilt-wearing bagpipe player. Public sympathy in the end clearly favored the position of those protesting, and the trade deal was never signed. There are photographs both of the police line and teddy bear catapult in the reception area of my office, but they're also captured in the full text of the book. I'll move on quickly. I've included a quote here from the then Chief Justice of the Manitoba Court of Appeal. There have been instances in human history in which civil disobedience to law has proved a benefit to law and society. Quite a remarkable statement from a provincial Chief Justice of a Court of Appeal, and one that we've seen repeated and referred to occasionally by members of the judiciary. All right, I'm going to close just by quickly going through my list of readings. That starts on page 16. Saul Alinsky is the original. Gene Sharp, if you drop down, is the 3-volume collection of tactics and examples. And then I will take you to page 18 very quickly, a text by Erica Chenoweth and Maria Stefan, Why Civil Resistance Works, the Strategic Logic of Nonviolent Conflict. There are two profs at the University of Colorado who did this study. I set it all out there. I think it's simply one of the best tactical blueprints for conducting civil disobedience. And then on page 19, I set out the 6 key features. Now, let me just quickly close by mentioning quite an extraordinary publication, which isn't included in my list because it was published shortly after that, but it's the Lawyers' Rights Watch publication entitled The Right to Dissent, A Guide to International Law Obligations to Protect the Rights of All to Participate in Public Affairs. And that's available free online. And if you go to the Lawyers' Rights Watch website, and it is lrwc.org, The Right to Dissent, you can download it free. It's also available through Amazon and so on. And it fills a gap that had existed for many decades in which judges simply did not understand the role that international law plays, the different treaties that we're obliged as a country to comply with, but they didn't understand the role that international law plays in defending the rights of civil disobedience. And have a look at that, and I think you'll find it useful in advising your clients. So I'm over, but thank you for your patience.
Thank you, Leo, and thank you for your dedication to this pod. Henry David Thoreau would be proud of you. We're, we're just going to move right along then to our next speaker, and then at the end of the speakers, we'll throw this open. But our next speaker is Professor David Millward, who's a member of the Beardies and Okamasas First Nation. His first book, Aboriginal Justice and the Charter, won the prize in 2012 for the best book published by UBC Press that year. He's author of The Art of Science in the Canadian Justice System, the Gladue Handbook, and various other publications. He worked on the Truth and Reconciliation Commission of Canada, helped complete the final reports on Indigenous justice. And David's going to be speaking to the relationship between Indigenous law and colonial law when people are defending their traditional territories. We're very honored to have you join us, David.
Oh, thank you. Okay, I'll start with a little bit about what the program that I'm part of, because it is relevant to what I'm talking about. So I'm one of the faculty members for the Joint Indigenous Degree Program that's been set up at the University of Victoria. Now, the idea is that it's modeled after the McGill, but it's Indigenous legal orders and common law. So the course that I teach is Trans-Systemic Criminal Law, which compares common law to Cree principles of Cree law. Now, it's easy to think that Indigenous justice is just about restorative justice or sentencing circles, but like anybody else, Cree law has to get into questions of what's sanctionable behavior and what's not. And a very large part of Cree law is what are people's responsibilities to the natural world. Now, for example, and a lot of these come out through stories about a trickster figure named Wasakachuk. Now, a lot of Wasakachuk narratives, part of the discourse is that animals, such as beavers and bears and wolves, take on a role that's almost equivalent to human actors in a different kind of story. And the implication, I shouldn't even say the implication, it's the internalized understanding of those stories, is that those animals have rights and expectations and privileges and possibly legitimate claims to grievances that on par or on the same order as human beings' legal grievances against each other. Now, another part of the story is that it does spell out repercussions when somebody does something that's unacceptable in terms of compromising the natural world or a human encroachment that's out of proportion on the natural world. So, for example, a story called Wasakachuk Steals Language, where Wasakachuk interferes with the tribe's ability to call a deer by its proper name, and therefore they're unable to bring the deer in for hunting. And that's considered an interference with a sort of circular contract and understanding between human beings and deer, whereby deer will sometimes occasionally give one of its life to help sustain a human society, but then the human society in turn is expected to show proper respect and appreciation for the deer. And ultimately, human beings are doomed to go to the ground, and that gives rise to the grass, which in turn helps feed the deer. So it's an eternal cycle. Now, when Wasakachuk interferes with this group's ability to be a part of that compact, ultimately he's undone. And I won't get into the details, but at the end, they subject him to public ridicule. So just like, wearing the yellow shirt in Singapore, if you publicly litter, public shaming and ridicule was very often a part of Indigenous legal orders, and this story is an example. But also, they ultimately end up banishing him. So he's left to his own fate. So there could be criminal consequences for doing that. things like that. Now, the other difference that I'll get into is that in Canadian criminal law, there's this distinction between true criminal offenses and regulatory offenses. So, for example, assaulting someone, a human being, is considered a true criminal offense because the thinking is that walking up and punching somebody in the face is considered an inherently wrongful action that needs to be sanctioned. Now, where the distinction comes in is for regulatory offense, for example, like catching a fish from a river. It's thought that looking at it, it's not inherently a wrongful act. But if you don't put any checks and measures or legal restraints on it, the unfettered exercise of doing things like catching fish can lead to what's known as a tragedy of the commons, that people's ability to thrive and function as a society can be compromised if they don't place any legal restraints on the exercise of an activity that in isolation, well, there's otherwise not a big deal. Now, Indigenous legal orders would regard that, and I talk about this in my class, Indigenous legal orders would regard that distinction as a false one. Because doing things that result in the depletion of a species, or hunting an animal and killing it when there wasn't a sustenance need for that, or killing an animal and leaving large portions of it to rot, or doing things that, for example, poison a river, all these sorts of things, from an Indigenous legal order, they're pretty much on the same level as assaulting or even killing a human being or stealing from another human being. So it's a false dichotomy from an Indigenous legal perspective. And therefore, when you do those sorts of things, you're subject to true criminal punishment just as much as, for example, Canadian law would want to say to morally condemn things like assault and hate crimes and deliver true criminal punishments for those. So that's a key difference that has to be appreciated. So having provided that background, in some ways, and you can't fault Calvin and any of the other organizers because this is the lingo that we have to work with. But I have had this discussion with Leo before where civil disobedience is in some ways a bit of a misnaming of what's actually going on when Indigenous peoples do things like blockade pipelines or blockade logging access to their lands because of quite conventional stereotype view in the Canadian media and the Canadian public at large as you have these unruly Indigenous protesters who are breaking the law. And when I'm on the other end of the phone, I'm surrounding the law in quotation marks because it's an assumption, well, there's only one law, Canadian law, and these Indigenous people are just breaking the law and they should be dealt with accordingly. What gets lost in that depiction is that a lot of these Indigenous protesters, I would venture to say a good deal of them don't actually recognize Canadian law's legitimate authority in the situation. They actually see themselves as acting under the commandment and imperative of their own legal orders. And from their perspective, if they do not go out there and block the pipeline, or if they don't go out there and block access to their lands, they would see it as themselves being neglectful and derelict in their responsibilities to their communities and to their own legal orders. So that is a perspective that needs to be kept in mind, and one that I'm not sure a lot of people properly appreciate, even in legal circles. Now, Leo Grady invited me to talk a bit also about my article, which has been uploaded to the materials. So I'll just try and burn through it in a few minutes. So the article that I'm dealing with, the article that I wrote in 2009, I sort of built it on two foundations. And what I'm trying to do is trying to in some way find an argument for legalizing civil disobedience within Canadian law. So there's two foundations to it. One is the Roncarelli-Duplessis case, where Premier Maurice Duplessis tried to instill himself as a liquor minister and suspended Roncarelli's liquor license just out of pure spite for posting bail for Jehovah's Witnesses. Now, the Supreme Court said, when you exercise that kind of authority, it has to be tied to the law itself. Like, for example, liquor safety standards. You just can't do it as a capricious exercise of power that's not actually tied to the law itself. So it's an early statement on the rule of law. The other part is HIDA. So when there's outstanding Indigenous claims and there's some uncertainty about what the strength of those claims are and whether the Canadian governments can go ahead with, say, for example, a development project. HIDA says if there's a strong Indigenous claim to that area, the Canadian government may have to hold off, and in fact may have to accommodate Indigenous interests in the interim. So I've taken these two together, and basically what I've said is that when the Canadian government or provincial government undertakes actions that are destructive or impinge on Indigenous interests, and in a way that doesn't comply with HIDA, that those kinds of actions are actually contrary to the rule of law. So when Indigenous protesters take to those things, especially when they haven't been consulted, but then the state sends in the police to arrest them and all the rest of it. Ultimately, my argument is that the Canadian state has disentitled itself from prosecuting the protesters, and therefore a judicial stay would be the appropriate remedy. But that's sort of my article summary in a nutshell, and I think I'll stop there.
David, thank you very much, and I'm sure there's going to be a lot more discussion at the end of the speakers here about those very important issues. Karen Campbell from EcoJustice is going to follow on with a discussion about the impact of British Columbia's new legislation, the Declaration of the Rights of Indigenous Peoples Act, and how that might dovetail with some of the issues that you've raised, David.
Calvin,
Thanks
I'm just wondering
Calvin.
if we want, this is Deborah, half a sec, Karen. I'm just wondering if there's anyone who has any clarifying questions.
Great.
So more on just clarity of content as opposed to getting into our discussion
Great.
At this point, things
Yeah,
that
very
will
brief.
just help to, yeah. So you can either ask in the chat box or jump on.
You may have to unmute yourself because I'm muting people so the speakers are not interfered with.
Okay, let's move on. But after Karen, we will also ask the same question if people have clarifying questions, just to keep this a little bit interactive. Thanks so much, Karen. Go ahead.
All right. Thanks very much for having me here today. I'm actually kind of honored and tickled. I was happy to be invited because I would have liked to have attended anyway, so I'm not sure I would have known about it. I am no longer with EcoJustice, actually, but I am working with a firm called Ingers Fong in Vancouver. And in that capacity, one of the things that I did last year was I was one of the lawyers that was involved in the Coastal GasLink decision, that wretched, horrendous injunction ruling of Madam Justice Church that came down on the last day of 2019, which was a terrible result in Crown law, but inspired Indigenous protests across the country, the Wet'suwet'en protests in support of the Wet'suwet'en peoples and the Coastal GasLink. And so that's, I think, to go to what Leo's been talking about, is this idea that protests, the result of a protest, it can often be much bigger than the legal context in which it takes place, and vice versa. I really appreciate what Professor Millward is saying about the role of Crown law and how it does not recognize Indigenous legal perspectives. And what I really want to do in this few minutes that I have is just talk briefly about, would the Coastal GasLink result be any different now that we have in British Columbia this new Declaration on the Rights of Indigenous Peoples Act? So I'll try to do that really quickly, and if there's questions, I'm happy to take them. So in the Coastal GasLink case, what the court said is that the injunction prohibits the Wet'suwet'en land defenders from upholding their own Wet'suwet'en laws. And this is exactly what Professor Millward was saying, is that Indigenous people are acting from their own legal order perspective, and they don't actually need Crown law to do what they believe needs to be done to defend their land. And this case says very clearly that Indigenous laws don't become an effectual part of Canadian law until they're recognized by the Crown. And so one quote from it is while Wet'suwet'en customary laws clearly exist on their own independent footing, They are not recognized as being an effectual part of Canadian law. Enter the Declaration on the Rights of Indigenous Peoples Act. This is a new piece of legislation that was passed unanimously last November by the BC legislature, and it is a framework legislation that establishes an ability to implement the United Nations Declaration on the Rights of Indigenous Peoples. It is intended to recognize the UN Declaration, so it therefore means we're recognizing the right to self-determination of Indigenous peoples, the right to self-government of Indigenous peoples, the requirement that states consult and engage with Indigenous peoples through institutions that are chosen by those Indigenous peoples. So not necessarily Indian Act requirements or band councils or any of the other Crown structures that the Crown has decided to recognize, but Indigenous recognition. At a really high level, the Declaration Act requires BC to, quote, take all measures necessary to implement the UN Declaration. It establishes a couple of very specific tools for the Crown to make real this commitment to implement it. And that's there's agreement tools, and then there's an action plan that is intended, I think, to deal with legislative reforms that will come about. And the third piece that's really critical, and I think of particular interest to this conversation, is this idea that the Declaration Act will recognize Indigenous governing bodies. And it defines an Indigenous governing body as bodies that are designed to act on behalf of Indigenous people and that hold Section 35 rights. And the definition works such that Indigenous people will define who those Indigenous governing bodies are. So it's not up to a Crown definition, it's up to the Indigenous people to do that. And because I only have a few minutes, having set out a new legal framework in 4 bullets, I'm going to turn to, would the Coastal GasLink outcome be any different under this new Declaration on the Rights of Indigenous Peoples Act? And I think at a really high level, my short answer is it's not immediately clear that it would be. I think that the court analysis in something like that injunction application, that Coastal GasLink injunction application, there's no question the court analysis would have to be wildly different because it's a very problematic analysis. But because of the way this is sort of an initial foray into Indigenous recognition by a Crown government, but because of the way that is being done, there is no guarantee that you'd see a very different result, because the Indigenous governing body's ability to represent its perspective and to actually enforce its own laws is still going to be subject to some sort of Crown action. So if there is an Indigenous governing body that says we'd like to take on statutory decision-making powers or we'd like to strike these agreements, there is still an ability for the Crown to say we will or we will not recognize that. So I think that what we could well see in the future, in the context of protest and in the context of land defense or civil disobedience, depending on the perspective, and I prefer to think of it as land defense, I think that with the new legislation in British Columbia, it could well be that you will see an Indigenous governing body protesting some form of Crown law, some Crown decision, and it could be a pipeline, it could be forestry. They tend to be natural resource disputes quite often. But we don't know exactly how that's going to unfold. And it could be that you see land defenders who are undertaking these actions, and for it to be justifiable, it might be that it needs to be done with the blessing of an Indigenous governing body. So there's a lot of new opportunity to figure out how to reconcile Indigenous legal orders with the Crown and to come up with new ways of addressing, frankly, these pretty problematic and chronic situations when it comes to Indigenous land defenders trying to address resource development. That's probably an awful lot, and I'll just leave it. Thanks. Thanks so much for having me.
Thanks, Karen. So, Deborah, did you want to call for points of clarification before Lauren speaks?
Yeah, that would be awesome. So if anyone has any clarifying questions, I think, Holly, are you still muting me or can you hear me?
We can hear you.
Hear me? Okay. Thank you. If anyone has any clarifying questions, we have a long question from Gail, which we can deal with at the end when we get into our conversation or discussion.
Great. Okay, so we have this enormous issue of land defense and indigenous rights and people, the role of people that are defending indigenous legal orders against incursion against the indigenous law. The other big issue here is the necessity defense when people are protesting things like climate change that do raise that very real issue of necessity for taking action. And we're really pleased to have Lauren Regan here from the Civil Liberties Defense Center in the United States. She's represented over 4,500 political activists in civil and criminal litigation across the United States. And the exciting thing is that in February, Lauren presented the first complete climate necessity defense to a U.S. jury in Portland, Oregon. The case resulted in a hung jury and dismissal of the charges. And prior to that, Lauren has won precedents in Minnesota and Washington courts, where courts confirm that climate defenders have the right to present a climate necessity defense along with expert testimony to a jury. So we're really pleased to hear from Lauren.
Thank you, Calvin. I am excited and honored to be here. I guess I will start by just saying that my organization, the Civil Liberties Defense Center, supports movements that often seek to dismantle the political and economic structures at the root of social inequality and environmental destruction. We do that around the United States by providing litigation, education, and legal and strategic resources. We work in both Indigenous and non-Indigenous communities, but as many of you probably know, the U.S. is woefully behind with regard to legal protections for Indigenous organizers. And so today I am basically going to talk about the use of the necessity defense in the U.S. And then I'll just briefly talk about the two cases that Calvin just mentioned. So in the U.S., we have been advancing the climate necessity defense for probably almost 20 years. And as Calvin mentioned, just a couple months ago was actually the first time that a court has allowed us to not only present the defense, including expert testimony, but also gave the jury an actual jury instruction and allowed them to deliberate on the law. In the U.S., the climate necessity defense is a political legal tool used by climate activists that are usually intentionally getting themselves arrested, so they know that there's potential legal consequences, and we're using that defense to try to justify and draw attention to their protest actions, to their economic disruption, to their direct action taken in defense of the climate. The defense uses the procedures and language of the U.S. legal system to educate the public and jurors about the risks of climate change, particularly with regard to like science, policy, and the efficacy of civil disobedience within the courtroom. In the U.S., the necessity defense varies by jurisdiction on like a state-by-state basis. Some states will utilize the common law, which I guess is one of the potential nexuses between what I'm going to talk about and maybe how it could be useful to y'all, because obviously, you know, we share that as sort of a starting point is with regard to some common law. Other states will actually have specific statutes that set forth what is called either the necessity defense, choice of evils defense, sometimes it's called the justification defense, and in some states like Montana, it's often just called the compulsion defense. But in general, in the United States, a defendant is required to show, number one, that they faced an imminent danger. Number two, that they took action to prevent that danger through a less harmful means, sort of a balancing of harms. Three, that they reasonably anticipated that the action would prevent the danger that they were seeking to avoid. And four, that they had no reasonable legal alternative to the action, to taking direct action. And so in most instances, the courts have prevented the presentation of the defense prior to trial, thus depriving juries of the opportunity to hear the defendant's justifications. And most often, the courts have basically ruled, in my cases especially, that climate change was not imminent enough, that they claimed that we couldn't establish that the harms that we're seeking, that we were seeking to avoid were imminent. And so in some ways, it's kind of sad that we've finally gotten to a point where the courts are ruling in our favor, because in essence, what the court is ruling is that climate harms are happening now. The manifestations of them are visible and basically almost uncontroverted. And so as a result of the fact that that's where we're at with regard to climate defense, the courts basically are saying that it's up to a jury. In the U.S. legal system, and I think yours as well, we have a constitutional right for defendants to present defenses of their choice to a fact-finding jury. And so the hook that we finally have kind of landed on is that the courts, including several state Supreme Courts, like Calvin mentioned, specifically Washington and Minnesota, and I guess another little nexus here is in those two cases, I represented valve turners that went to the Canadian border, basically, in order to stop tar sands from coming into the U.S. So these were counties within the state of Washington and within Minnesota that were literally directly adjacent to the Canadian border. And in both of those cases, because of the appeals that happened, they ended up basically going all the way up to those state Supreme Courts. And so now it is the law of those states that a defendant, when a defendant raises a defense of necessity, climate necessity, the courts have ruled that they're allowed to do that if the defendant can demonstrate that they reasonably believed the commission of the crime was necessary to avoid or minimize a harm. The harm sought to be avoided was greater than the harm resulting from the violation of law, and the threatened harm was not brought about by the defendant, and no reasonable legal alternative existed. So basically what we are doing now with these cases is, number one, we have climate experts like Dr. James Hansen, and other kind of famous climate scientists who basically say climate change is happening now. It is an existential threat to the survival of the human species as a whole, and it's happening in that state. Talking about sea level rise or talking about forest fires, wildfires, talking about pests or pandemics or other things that are directly correlated to the science. And they're saying it's happening now, it's happening in Washington or, whatever state it is. The next thing that we bring in is some kind of climate law and policy expert saying that as a result of the overwhelming corruption of the fossil fuel industry's billions of dollars, that the normal democratic systems that we would use to effect change for ourselves as people in a democratic society are totally broken. That because of the bazillions of dollars going into state legislatures, going into media, going into lobbying, et cetera, that we can no longer rely on those democratic structures to advocate change. And And then the third thing is we use an expert to talk about the efficacy of economic disruption, civil disobedience, et cetera, et cetera. That person saying that because those structures are totally broken, there really are no reasonable legal alternatives to direct action. And historically, nonviolent direct action has gotten the goods. And I think, as Calvin mentioned at the beginning, I think it was Leo McGrady mentioned we utilize the studies that have been done by Erica Chenoweth and Gene Sharp, and all those kind of pillars of CD. In that last trial, we utilized a professor who used their statistics and basically got on the stand and said, in essence, direct action, has been effective historically in the past. We utilized historical examples, like for the U.S., we used the lunch counter sit-ins, and when federal law was not going to force private corporations to desegregate and to not be racist, then people moved into those corporate settings like a grocery store, like a store, and literally clogged up the works until those corporations were forced to change their policies in order to continue doing business. I think that is sort of something that, especially with regard to the fossil fuel industry, is going to be tenable. And so in those cases, the court said, yep, you passed the sniff test. And so now it's up to a jury of your peers in order to do that balancing and decide whether or not you're going to be found guilty or not guilty at the end of the case. It's still a huge ask, even when we're allowed to present all of this stuff for 6 or 12 jurors to say, yeah, you get to break the law for climate, because it really strikes at their sense of safety and security in terms of like normal, moral norms, I think. So, for instance, in that case that Calvin mentioned that we just did in February in Portland, we put on an awesome trial. We got to put all those experts on. There were tons of media recording it. Tons of outreach and education was done. And ultimately, 5 out of 6 jurors voted to acquit the defendants. When they did that balancing, they said that the scales tipped in favor of exonerating them, even though they blatantly locked down on railroad tracks going into a tar sands facility. No doubt that they were trespassing and should have been found guilty. 5 out of 6 of the jurors said not guilty. The 6th juror, just to kind of frame this, was a physician, white, 70-year-old male. And I think, I don't mean to stereotype, but I don't think we were ever going to convince him that there was ever a justification to breaking the big LAW. That just was not part of his worldview that we were ever going to change. But because that was a hung jury and a mistrial, the state chose not to prosecute them again and dismissed all the charges. Big victory. The other thing that happened during that trial, and I think why the state gave up, was because we got to put on everything bad about this tar sands corporation. And the corporation was just the victim. They didn't get to put on any testimony about why they were great or why what they did was useful. So we got to just basically lambaste them with all of the worst stuff that they could ever possibly have come out in a courtroom, and they didn't get to argue against it. And the state, through the district attorney's office, tried to poke holes in our case by saying things like, well, did you ever plant trees? Did you ever, donate to Greenpeace? They did a pathetic job of trying to poke holes in a very, very strong presentation. But ultimately, I think that corporation went to the state and was like, we don't want that to happen again. We don't want them to have a second bite at making us look like dirt balls, in a courtroom. And so I think that the fossil fuel industry in general is also learning that if we get to use these kinds of defenses in the courtroom and get to have, our day in court using dramatic theater, as part of that political process, that they end up with the short end of the stick big time, in a way that is powerful, even if the jury comes back and says, we find you guilty. The fact that we're able to put that whole song and dance out on a court record, in sort of the laboratory setting of a courtroom where the jurors get to see up close and personal these experts. When Jim Hansen is testifying in a small Washington County courtroom to, these 12 jurors, it's very powerful for them to hear firsthand his, lofty scientific credentials and then his opinion. So when each of these people that show up in a suit and tie talk to them about why we are so over the barrel when it comes to climate change, and that our systems are so broken that our only hope is to take power for ourselves and put our, monkey wrenching, the big machines, gears and wheels, I think that is incredibly powerful in the courtroom. And so we're having a lot of fun with it. We've put together like a whole army of expert witnesses. At this point, actually, we have academics and policy experts calling us, asking us if they could be the next experts in the next case. So, I think for a lot of professionals that have anything to do with climate and direct action, they see this climate necessity defense as being sort of an exciting, interesting way to use their brains for the good of the climate movement. And I think so many of us are trying to figure out how can we use our credentials and our education and our licensing to do something to save the planet from catastrophic climate change. And so this is one tool that if you can start to warm it up, it seems like the gates then open. Once we got 2 state Supreme Courts that said, yes, you can present this to a jury, now we have district attorney offices not even challenging our presentation of choice of evils or necessity defense because they don't want it to go up to their state Supreme Court and create statewide precedent in our favor. So now they're not even challenging us. We're just doing it. And, and it's one jury at a time. But, it's creating a lot of excitement within the movement. And I think as well for lawyers. And I'm always happy to share any of our briefing, expert names. If you ever need anything that might be transferable between our countries, I would be happy to assist in any way possible. And I guess I would say, if we can do it here in the U.S., given our small, orange, unstable genius running the country at the moment, then I think you all have a really good chance of doing something similar up there. And with that, I'll turn it over.
Thank you so much, Lauren. That was just fantastic. And I think probably very, very inspiring for people here. So are there any points of clarification? I know that Keegan Pepper-Smith was just going to take a couple of minutes to do a comment on the Canadian necessity defense, but should we just ask if anyone has a clarification point first? If not, then Keegan, you're on. Tell us about all the avenues for necessity defense in Canada. Keegan works as a lawyer with EcoJustice and was involved in an intervention application on a case where the necessity defense was being raised. Take it away, Keegan.
Can you hear me okay?
Yep.
Nice, okay. Thanks, Calvin. So I've just been asked to provide a quick summary of the state of the necessity defense here in Canada. within 5 minutes or less, and ideally less, because I'm the only thing standing in the way of hearing from Professor Rhodes. So I'll try to be speedy with it. So thankful for me and for everyone else on this call, the state of the defense here in Canada is much less developed in relative to our neighbors to the south. Unlike them, who've been trying to raise this defense for the last 20 years, I'd say it's only really kind of been raised in Canada within the last 2 years, at least in terms of the climate necessity defense, which I'm going to focus on climate specifically, climate activism specifically. But for those more interested in the history of the defense, more generally in Canada, and with respect to protecting the environment, there's a really great article written in 2013 by Hugo Tremblay titled "Eco-Terrorists Facing Armageddon: The Defense of Necessity and Legal Normativity in the Context of an Environmental Crisis." And that's available for free on CanLE, and that provides a really great background understanding of where the defense has been and where it's going. So before I get to the Canadian context in terms of the climate, just one point that I think it's important to make is that the elements of the defense are slightly different here in Canada compared to the federal and state criminal law systems down in the States. So unlike the elements that Lauren spoke of, we don't actually have a requirement that the accused reasonably believe that the action would address the peril. So, for folks like Hugo Tremblay, that actually seemingly makes the defense more available here in Canada, because the accused doesn't have to reasonably think that stopping a particular pipeline is going to, stop the climate crisis. So that's a nice aspect of the Canadian elements of the defense, but that's about as far as it goes. The rest of the elements are exactly the same, and it hasn't been given much favor here in Canada, unfortunately. So turning to the climate necessity specifically, to the best of my knowledge, the only place that it's actually been raised is in British Columbia in defense of contempt of court charges relating to acts of civil disobedience against the Trans Mountain Expansion Project. So we all know the context. Over 200 people were arrested for violating an injunction in and around Burnaby. So throughout 2018 and 2019, several of those accused brought pre-trial applications to raise the defense through what is known as a Bukolich hearing to determine whether the defense on proposed evidence had an error reality or any basis upon which it could succeed at trial. And so the long and the short of it is that none of those accused got past that pre-application stage, with the trial judge summarily dismissing each one of those applications. So that could end the conversation there, but there was actually one decision that's particularly noteworthy. That's because the accused, among other things, brought an incredibly detailed explanation of the evidence of climate change, its associated harms, and how the project and related oil sands expansion would contribute to the crisis. And he did this to satisfy the imminent peril element of the defense. However, the judge refused to accept that there was even an error of reality to the claim that climate change constitutes such an peril. And so I just wanted to quote from paragraph 55 of that judgment, because I think it just very succinctly captures the judge's thinking on the issue. And so the neutral citation for this judgment is 2019 BCSC 50. And so from paragraph 50, quote, "On the evidence the applicants seek to offer, rising global temperatures to a level that is catastrophic to life is a process that has been happening for over many decades. Despite a historical lack of initiative to curb emissions over the same decades, adaptive societal measures may be taken to prevent such a dire outcome. Whether government and private industry and citizens take these measures is a contingency that take these consequences outside of the virtually certain into the realm of only foreseeable or likely." So I think that just captures the state of affairs in Canadian courts. We might not have such an egregious leader in our federal government, but I don't think anyone else on this call would debate the fact that we have quite conservative judges throughout our judiciary. And this, I think, very much captures that state of affairs. Instead of recognizing climate change and its associated harms as a given without requiring any particular evidence, leaving aside adjudicative facts required for a defense to be successful, talking about legislative facts or societal facts about climate change, he went the other way. He said, look, this is, without any evidence to substantiate it, he just said, look, this is something that might happen, it's foreseeable or likely, but we can do something, let alone, despite the fact that we're undergoing a massive expansion of our oil sands. So that's the latest out of Canada. The two accused in that particular case have brought an application to appeal the decision. EcoJustice applied to intervene on that particular case and that particular issue, that there is no such thing as imminent peril in climate change. Unfortunately, our application was dismissed, so we're not going to be a part of that case. But the last I heard, the hearing for that appeal is scheduled to go ahead on May 29th. So we're going to be watching that closely, and we'll definitely be watching it closely to see if the defendants appeal whatever decision, or, not to prejudge the decision coming out of the BC Court of Appeal, but I'm assuming that eventually it might end up at the Supreme Court. So that's where we stand in Canada.
Thank you so much for that, Keegan. If there are points of clarification on what Keegan had to say, speak now or forever hold your peace. Otherwise, we'll move on to Professor Kent Roach.
Thank you. Can people see me, or is there still a problem with the video?
You're looking good, Kent.
Oh, okay.
Yeah.
Well,
hey, let me just introduce you here first.
Oh, okay. Sorry. Well, no, you've already mentioned enough. So,
okay, go for it. It's a resume to dream for.
So look, I'm really happy and honored to be here, and I'm just going to really wrap this up quickly before we get to questions, more as a general rapporteur who's been learning a lot from all of our speakers. So there's about 4 points I want to make. The first one, and this really comes out of both Leo and David's talk, is I think we need to rebrand civil disobedience. I mean, on the one hand, it has an honorable history, Gandhi, Martin Luther King, but I think, as has been indicated, this is often something that is done with a firm and reasonable belief that it is being done in accordance to law, whether that be Indigenous law, international law, or the Canadian Charter of Rights and Freedoms. And I say this not only as a semantic point, but I was taken by Lauren's comment about the one juror who had, it was all about the rule of LAW. I really do think that in order to address Canadian jurors, or more to the point, as I'm afraid this will often be the case, just Canadian judges, we have to take away that idea that they are vindicating the rule of law, which is often, as the reading from my book suggests, the rule of an injunction against a protest that a single judge has issued. And so this is something, obviously Indigenous law has made us more sensitive to this, Justice Fitch's, but I also think of Robert Cover in a wonderful piece called Violence in the World, where he was talking about how every time a judge makes a ruling, he or she is actually often delegitimizing a sense of normativity. So although I've referred to it as civil disobedience in my own writing, I think that civil resistance, dissent, or something better that we come up with as a group in our discussion would be a good first start. The second point is, and this really comes from Karen's talk, that even with the new BC legislation, I was struck, because I think Karen's right, that this phrase Indigenous governing body in the new BC legislation is quite relevant. But I was struck by the parallel between that and the Ben and Moulton construction case from the Supreme Court, which I gather has been cited in a number of the BC Supreme Court's recent decisions about injunctions against protests, dissent, civil resistance. And so I think that Karen is right that as difficult as it may be, especially in situations where there are two or more governing authorities in an Indigenous community with claims to govern, that Ben and Moulton construction is a real problem. Right, because it suggests that when protesters violate an injunction against protest, often obtained by a resource company, that they will have really very limited defenses to raise. They will not have a right to a jury trial. I think that this is something that we in Canada are having to deal with. Now, following David Milgaard's 2009 article, which I would commend you all to read, you might want to look at footnote 122A of my handout, which is a Newfoundland Court of Appeal decision, Nalcor Energy. And it leaves open, the majority does, David's argument, which I think is quite ingenious, which is that the duty to consult in HIDA could be used as a possible defense in cases where the consultation has not taken place, or perhaps not taken place in a truly by juror way. And the Court of Appeal, although as too many of our cases do, affirmed the injunction against the protesters, leaves that open. Although it is kind of ominous that Justice Rowe, who's now on our Supreme Court, objected to this and stated that any allegations of the breach of duty to consult cannot be raised in challenging an injunction. So third, and this goes off Lauren and Keegan's very interesting discussion of the necessity defense. I think that, Lauren has really set out a very inspiring vision to have both climate scientists and I guess political scientists on call as experts. And I think that, certainly if you look at a case like Bedford, there is an appetite among Canadian academics to participate in this sort of affair, but it has to be done and lined up ahead of time, even though a lot of these things, as I indicate in the excerpt from my book, are cases where perhaps the Indigenous party has tried to go to court to get an injunction. The development company then's come back with its own request for an injunction, and this is happening sometimes quite quickly in motions court. So I think that that's something that needs to be thought of. I think that, though, as we heard from Keegan, that the big problem in Canada, or one of the big problems, is the SNOOS test for the air of reality, which I think shows less deference to letting issues go to the jury than you saw in the Washington case that was provided for us. So the SNOOS test is, could a reasonable jury acquit? And of course, the three-pronged necessity test in Latimer, common law test in Canada, is imminent peril, no legal way out, and proportionality. Now, I do think that in Latimer, reading between the lines, the court might have ruled differently, or at least been open to expert evidence on what in Canada, Canadian criminal law, is called the modified objective standard. And this goes back to Lavallee and the introduction of battered women's self-defense, which and the use of expert evidence. Now, this itself is controversial among feminist commentators. There's a worry that this pathologizes or centralizes, but it seems to me that if I was running a necessity defense, I would want to not to pathologize those who protest and put their lives and liberty and reputation on the line, but I would want to try to educate the judge to try to get into the world of a reasonable person who is willing to engage in this kind of protest. I actually think proportionality is the least of the worries, because most of this stuff is small potatoes. But of course, all of this stuff about necessity really depends upon whether there is a criminal charge. And unfortunately, if there is a criminal charge, you may not have a right to a trial by jury, depending on what charge it is. And of course, the trend is to allow more things to be decided by a provincial court. So I do think that we need to educate our judiciary to be more cautious before they introduce these sweeping injunctions against protests. And I also think academics, including myself, need to do more work on criticizing some of these rather sweeping injunctions. And then the last thing I'm going to say, and this is a little bit of a spanner, but as Lauren points out, and I'm not even sure this is viable in Canada right now, we can fight this jury by jury. But one of the things that might be interesting to think about, and this is a long-term project, is take a case of a convicted civil resistor. And perhaps even convicted of criminal contempt. I'd have to think about that and do more research. And the government, the federal government, has pledged to introduce a criminal case review commission to replace the 696 process for miscarriages of justice. And you can imagine a situation where you would have new evidence, all of the evidence that was not led, and you could try to delegitimize these convictions of protesters through a well-chosen and well-argued application. Now, of course, even the new commission, which of course is not even a bill yet, but even the new commission could only refer it back to the court. But I'm pretty confident that the new commission, when it is eventually up and running, will, like the New Zealand commission, which is the most recent criminal case review commission, have at least one or two people with knowledge about Indigenous law. And that might also be another vehicle. So I think that this is a multi-pronged, and that's one of the reasons why it slips through the cracks. Sometimes for legal academics, we have to look at the injunction issue. We have to look at how police enforce injunctions, and we have to look at the defense of necessity, and then also the criminal case review commission. So that's really all I have to say, and I'm looking forward to hearing from everybody else.
Thanks so much, Ken. And now we have a half an hour to talk about this. A lot of ideas on the table. Deb, did you want to moderate the questions?
Yeah, I'm happy to do that. And wow, just can I say thank you to all of the presenters. This is not at all my area of law, and my brain is really full and sparking a lot of interesting ideas. So I can imagine that a few of you on the call who engage in this and think about this in a more detailed sort of legal strategy way are really excited by this. I notice at least 3 people from EcoJustice on this call, as well as other litigators. We have 2 questions in the chat box, which will start us off, and then I invite people to jump in after that. So the first is a question and a comment from Gail. The first is a question: is the ELC going to assist in the defense of the 14 people arrested at Strathcona School for trying to bring public attention to the need of homelessness in shelters, sheltering SRO housed people for places to self-isolate while having access to food, medical care, and other necessities? And I take that this is around the COVID-19 stuff. So the short answer to that question, I can answer it, is no, the ELC will not be defending anyone because we don't take on counsel of record duties. However, what we do is we provide support to lawyers who are doing that. So if it works out in any term, the way that our term roster works, we could provide support for that kind of work. But then Gail goes on to make a comment that what is needed is not only work on the defense of necessity to include civil disobedience, also needed are knowledgeable presentations to courts, judges, and lawyers about the existence, meaning, and scope of the internationally protected, e.g. by the ICCPR and UDHR, right to engage in protest, criticism, and dissent as part of the rule of law, and democratic rights to expression and to participate in government and public decision-making. These arguments have not been presented in defense to any injunction applications to prevent protests of mega projects. Judges and lawyers are seemingly unaware that the right to protest, criticize, and dissent is a charter-protected right, while the right to pursue a development contract is not. And then Gail directs us to the excellent LRWC publication, The Right to Dissent, a guide to international law obligations to protect the right of all to participate in public affairs by engaging in criticism, opposition, and dissent. And the book is also available free online at the URL below, which is in our chat box. And I'm not going to reproduce it here, but we're happy to send it out afterwards because Holly has some additional materials to send out after our video conference ends. So thanks very much, Gail, for that. There's also a question by Patricia. Would you like to ask it yourself, Patricia, or do you want me to go ahead and do that? Okay, I'm happy to do that. Patricia says it would be interesting to hear from Leo and others about the use of theater in the courtroom, as we don't often have juries, so maybe this is very different from the United States to Canada.
Shall I go ahead and answer it? Okay.
Yeah, go ahead.
The kinds of presentation that we heard from Lauren are not unusual. I guess they're a bit unusual, but they're certainly admissible in Canadian courts in these types of cases, this kind of expert evidence that Laurel is speaking about. I'm not exactly sure what Patricia meant by using theater in court. If it's literally theater, we may have a bit of a problem, and I wouldn't think that the courts would be particularly receptive to it, nor particularly swayed by it. But I do think, and I can't emphasize this enough, the use of theater as part of the protest is simply marvelous. And in addition to the nonviolent feature, is probably, in my experience, the single most valuable quality of effective civil disobedience. And the classic that always comes to my mind is at the Free Trade of the Americas demonstration in Quebec City, with the bagpipe player dressed in a kilt and wearing a gas mask and playing the bagpipes. That got just huge international coverage. The other part of the theater at that protest was the teddy bear catapult. I mean, that was a stroke of genius to see these folks with a medieval style catapult and successively loading boxes after boxes of teddy bears and throwing them over the chain metal fence into these heavily armored riot police. And that also went worldwide, and I think it's been a very significant contributor to the success of that demonstration. And I don't recall there being any charges laid other than one against a Quebec provincial police officer, 3 of them, in fact, who had presented themselves as demonstrators in an attempt to foment violence, and they were uncovered by one of the demonstrators, and that led to charges. But I don't believe any of the others were charged. And you can imagine the difficulty the Crown might have in having a judge, or even better, a jury, take seriously the playing of the bagpipes or the use of the teddy bear catapult, suggesting that constituted criminal conduct. So I think that would be my response, and I hope it's responsive to Patty's question.
Thanks very much, Leo. Lauren, I'm wondering if you want to say just a little bit more then about what I took down as dramatic theater as part of the political process. So in court, what is the importance of that in the way in which you shape the way in which you present your case? And just recalling that here in Canada, we're mostly talking to judges, not juries.
Yeah, and I think one thing I would like to point out in response to what Leo just described, for us in the US with regard to using necessity or justification, it has to be more direct action than civil disobedience. And what I mean by that distinction is you have to want to shut down all tar sands coming into the US and then turn the valves and actually shut it down. You can't stand in front of the valves and perform mime and hold signs, because that's symbolic, and symbolic action would not rise to the level of justifying a necessity defense under US law. So that's one big thing that we always train activists about. If your campaign is planning to use necessity defense, you have to figure out a way that your action is actually going to at least do something to achieve the goal that you're trying to achieve. And what I meant by theater in the courtroom is, especially, even in the US, it sounds like, even though we are allowed to use juries, which I think is much more powerful and effective, because you've got 12 lay people who are being told that they're the conscience of their community and that they have the role of determining the moral compass for society. And they don't want to put billion-dollar profits above clean water and a livable future for their children. When they start doing that balancing, it sometimes changes, as compared to a judge. But even if you are, at a bench trial in front of a judge that's going to give you no love, you still have, for the clients especially, they know they're risking arrest. They know there are legal consequences that are very real, but they're doing it because they're trying to get media, they're trying to educate the public, and oftentimes where you are in that courtroom is also the front lines for the fossil fuel industry. Where people are getting arrested and where they are in court is also the community that is most affected by the destructive acts that are going on. And so even if the judge, is going to give you nothing, you are putting all this evidence on to a packed courtroom often. I don't know if you guys are allowed to have cameras in your courtrooms or not, but often it's being filmed and then, used as part of the actual campaign. So for clients, especially activist clients that are purposefully risking arrest, to be able to use the courtroom as part of their campaign to further the goals of their campaign and to somehow legitimize why they did what they did and for that cause really elevates their message in a way that wouldn't happen but for the fact that they were in that courtroom. And so when I use the word, theater in the courtroom, more I'm just kind of talking about the fact that you get to put on experts. They get to talk about their intent. At a minimum, they can tell the court why they did what they did. And to have, a 30-year school teacher get up on the stand and cry, talking about how, she felt like she had no option but to get arrested for the future of youth or, whatever it happens to be, it becomes really powerful. That's what I meant.
That's wonderful. Thank you. Do any of the speakers have any further comments and reflection on what Lauren is talking about in terms of strategy in the United States?
Yeah, it's Kent. Lauren, have you had any problems getting experts qualified? Because, I've run into, issues where I've been an expert witness and my impartiality has been challenged by the government. They lost, but it wasn't a great experience. And how much time do you have to work and train your experts? Because it sounds like a pretty sophisticated operation.
So far, we have not had any of our experts excluded as a result. Down here it's called the Daubert test, which is our expert test. We have not had any experts excluded for that reason, primarily because we are beating them off with a stick almost at this point. We have the creme de la creme willing to play along with us right now. And so, who is going to challenge Jim Hansen or, some of the other folks that we've been using so far? So that has not been an issue. What has been an issue is taking somebody out of the ivory tower with an extremely high degree of genius and expertise and have them be able to explain things like atmospheric science to a farmer from rural North Dakota who went through the 7th grade. But I actually have degrees in psychology and political science, and I often think the psychology degree comes into play a lot more. And so really what we spend our most time with the experts is helping them explain really complex topics in a way that normal people can understand. And I basically have figured out that it's really my responsibility to frame questions properly. And very often I will reframe, they will say some gobbledygook that has a bunch of acronyms and things in it. And then I will say, so professor, what you're saying is blah, blah, blah. yes or no, and he says yes. And then the jury, nods and smiles at me like, oh, she speaks English and he doesn't. So that's definitely, but, even Jim Hansen, I've used him now in, I think, 6 different trials. And the first time, I almost fell asleep at counsel table. But over time, now that he has had a few experiences with it, he's doing a lot more public speaking to normal people, out in the public domain. Like, I think as a lot of our experts are coming into normal society and trying to explain stuff to normies, they're getting much better in the courtroom too. But I would absolutely agree that it is on me to adequately prepare my experts. And when they get on the stand and the jurors are smiling and nodding at them and understanding what they're saying and agreeing with it, it's like a positive experience in both directions. It's sort of like saying good dog, like even the expert scientist becomes thrilled with themselves that they've gone from teaching physics to PhDs to explaining, what is the difference between weather and climate? Like, that's literally how we start, And so, yeah, it's been great. It might take a little longer time. The other thing that I will do is I kind of write out an outline and I explain to them, like, imagine that this is a Broadway play. We have all these different characters. We have to develop the story in a way that's going to be understandable. And here's my outline of how I think the story plays out. And they really appreciate being able to see the whole picture before they dive into the little subparts. So that's been really helpful in terms of witness prep. And then the other thing that I will often do is if I have a particularly problematic expert, I will videotape them. I'll record them on Zoom or something, answering questions. And then we'll play that back and I'll explain to them how they could say it in a way that would be more relatable, because they really want to be relatable. It's just that they don't have a lot of practice at it. And so it's just a matter of practice.
Thanks very much. Does anyone else want to riff off of that courtroom question before I move on to the next one? Okay, we have a question from Meredith, who starts off her question, perhaps a boring solicitor's question. I think I would reframe that, perhaps asking for free legal advice from the experts. She says, as a director of NGOs considering direct action an issue that has been, direct action is an issue that has arisen in voiding our insurance coverage, which often excludes coverage for unlawful acts. The concern is that someone might be injured during the direct action and then insurance wouldn't be covered. So I'm not sure if this is board insurance or just general insurance in terms of being endorsed by an organization itself. Leo or anyone else, do you have any comments about, if you are a board member of an NGO, what your comments would be in that situation if you're considering direct action?
I've never had that issue arise, so it's an interesting one and an important one. If one of your members or one of your employees was injured during that type of action, that would be a WCB matter, and I don't believe the same language is present in the legislation, although I must say I'm not certain of that. But with respect to general liability, the wording of the clause that you set out, I think, is about as accurate as you'll find. They exclude coverage for unlawful acts, but I'm hard pressed to think of how an unlawful act in a sort of peaceful demonstration might lead to an injury that would lead to an insurance claim that would be denied. And that, coupled with the fact that of all the demonstrations that I've advised on or attended or heard about, I've never heard this issue being raised. I wouldn't be overly troubled by it. And my inclination would be just go ahead and do it. But following the principles of nonviolent action and so on, I would just go ahead. I know we do a lot of intellectual property law and libel law, and I know that this insurance issue is raised constantly amongst directors of NGOs who are publishing critical works, and it's something to be concerned about, but not to stop you doing what you know is right and what you think you ought to do to bring about the change. For the reasons I've mentioned, I've just never heard of it happening.
Great, thank you. I'm going to open it up and offer anyone on the phone if you would like to ask a question, or anyone who'd like to ask a question in their own voice. It looks like Keegan has a question for Lauren, sorry, and then others as well. So first we'll go with Keegan.
And Deb,
Thanks,
I think
Deborah.
Jessica had a question earlier too that was sent in.
Sorry, who?
Jessica Maganet.
Oh, sorry,
Yeah.
Go ahead, Jessica, and then we'll go with Keegan.
Oh, hi there. This could be to anybody on the panel, but I've been thinking about the climate necessity defense and the fact that it's grounded in the principle that morally involuntary conduct shouldn't attract criminal liability, and the fact that that's a constitutional principle, like a principle of fundamental justice protected by Section 7. And I was wondering if anyone on the panel in the Canadian law context has thoughts on how that could be used to advance necessity jurisprudence, either in the climate context or more generally in the civil disobedience context in Canada.
Yeah, you're definitely right that we couldn't abolish the necessity defense, but I think because it's a judge-made common law defense, the judges at least think it is consistent with the Section 7 principle against punishing someone for morally involuntary conduct. And the essence of that is just that any reasonable person in the situation would break the law. In some ways, I think the modified objective approach that's available under the common law defense might actually even be more favorable than trying to argue it as a Section 7 principle, because it allows you to say that the people who are protesting are just better informed about these issues than say, the editorial writers that are criticizing the protesters.
Thanks, Kent. Did anyone else want to jump in on that one?
Sure. I have to admit I'm a little, I'm not exactly holding my breath about the necessity defense myself, because I actually did consider the necessity defense in my article. There's a couple of issues. One is the harm. In my article, I actually reviewed several Indigenous protest cases, and very often perceived necessity gets given short shrift. In fact, what that actually motivated me was a quote by a judge, Gandhi in India was justified and Martin Luther King was justified in the States, but they were protesting unjust laws. And here the Indigenous protesters are just disobeying just laws. So that kind of became the burr underneath my saddle. So sometimes there's just this cognitive barrier to even recognizing the Indigenous perspective on what's deemed necessary. Second, the balance of convenience test. We've all seen how that's played out when it comes to interim injunctions. Halting the economic downfall of allowing these protests to go ahead far eclipses petty Indigenous concerns. Now, they don't actually say it like that, but the spirit of the words, that's pretty much what it amounts to. So I have to admit I'm not waiting with bated breath for necessity to come to the rescue of Indigenous protesters, but I appreciate the efforts.
Thanks very much, David. Keegan had a question for Lauren.
Yeah, I guess it's somewhat related to David's comments. One of the things I didn't mention is the hurdles in at least BC, is that we have a BC Court of Appeal decision from former Chief Justice saying that he was of the opinion that any kind of work or action in society that's been legally authorized, so like a license to build a pipeline, for instance, you could never justify or raise the necessity defense challenging that, basically saying that work that's been lawfully authorized can't therefore be just challenged through the necessity defense. And I'm wondering if you just ever run into that sort of commentary from the courts down in the States. It seems like it's an elephant in the room in the cases that were recently brought up before the court in the Trans Mountain Pipeline context.
Well, in the U.S. context, what often comes up is some past protest cases where protesters were engaged in blocking abortion clinic access, and they were denied the necessity defense. And the courts ruled that because a woman has a constitutional right to that form of health care, that the necessity defense was not justified, in those cases. But when we're talking about climate necessity, and especially with regard to the fossil fuel industry, there is no constitutional right to pollute the planet or to kill off all living things. And so that issue doesn't apply. And in general, if the rulings of the court were to say, as long as some corrupt fossil fuel industry gets a permit from the guy they've paid off, that you can't justify the criminal act, then you would never be able to, especially against the fossil fuel industry, you'd never be able to utilize the defense. And so, when we're arguing it, we're bringing up the fact that there is no constitutional right to pollute the planet. The science is overwhelmingly in our favor with regard to the harms and with regard to the fact that, it is unlikely that our government systems are going to be able to help us. The iceberg is moving so slowly, to use a bad pun, that there's no way within the next 10 years we're going to get to where we need to get to in order to avert the worst consequences of climate change. And so that's the futility of making that the argument that you just indicated that the courts might make. It's definitely harder with a judge. I will absolutely concur. There have been a couple of cases on the East Coast where the people were charged with violations, which in the U.S. means that you're not entitled to a jury trial. It's just a bench trial. And in those cases, overwhelmingly, the courts denied the use of the necessity defense, or they let them present the evidence and then said guilty. So I do think that is a thing. And especially if you've got, you mentioned that you've got a lot of conservative judges, that's also going to be a problem. I think in the U.S., at least on the West Coast where I am, we have kind of a cadre of younger, slightly more progressive judges that are coming up in the ranks, who were public defenders and, or who did public interest environmental law or other things like that, where they're a little more aware and they're a little more connected to their communities. And I think for some of them, at least, they don't want to be on the wrong side of history. And that's definitely sort of the closing argument that we're trying to make to them is, do the right thing. Don't be on the wrong side of history. And yeah, it's still uphill, but sometimes it's not in the winning or the losing, it's sort of in the process of going through the motions. And, and like I said at the beginning, if you've got clients that, knowingly got themselves arrested and know that they may potentially go to jail or whatever the consequence may be, having their day in court is sometimes, the upshot to that defense.
Thanks so much, Lauren. We need to sign off, but I in your comments, I I think that we have a lot more faith in our political process, at least formally still here in Canada, because continually we see judgments, court judgments, where the judge says this is not appropriate to be resolved here. It needs to be part of the political process. And so it's fascinating that you're bringing up these very fundamental arguments around the political process is broken and we can't rely on it anymore, or we're not going to get action in this way. I want to leave us with one more comment, and then I'll turn it over to Calvin to just conclude in the next 30 seconds. We have a final comment from Rebecca Johnson, who says, I've been thinking about the discourses of disobedience and vigilantism together. I wonder if that would open up some space for imagining additional strategies. So we'll just leave that there and invite further comment. And Calvin, would you like to close us off?
Yeah, sure. So thank everyone for participating. I think that we should look upon this session and the recording and the coming together of materials that's happened around this session as maybe a starting point. We will be posting a number of the articles that have been provided by Gail and by Keegan and by Professor Roach. And of course, you have the things from Leo and from Lauren. If any other materials are relevant that you could send to us, we could perhaps post those materials too. And we'll see where this goes. I think that this has been a very wonderful discussion, and hopefully it will be fruitful and move forward the law around not just civil disobedience, but land defense, as was pointed out by David, and perhaps civil resistance that was pointed out by Kent. And for the associates, we will have another session soon. And for our guests and for the students that joined in, thank you for joining us. And I will just conclude not with the words of Donald Trump, but with the words of the anti-Donald Trump Provincial Health Officer Bonnie Henry and her 3 injunctions to all Canadians, which are to be calm, be safe, and be kind.
Thanks.
Thanks, everyone. Good night.
Thanks, Calvin.